Good morning, students. Um, Today we are going to complete intentional torts, and we are going to, focus on certain categories of intentional torts, and then we will proceed to negligence and other areas of torts. For your information, there are some questions in your tests on issues such as privacy and so on. As I, complete the topics, I will indicate which areas you need to focus on. Okay, so in the previous class, we looked at intentional torts. And basically, when you look at intentional torts, this is a category of civil wrongs whereby somebody deliberately causes you some form of emotional distress. All right. And these include new situations that we are facing today, such as sexual harassment, harassing by phone, cyber stalking, cyberbullying, etc. All right. So all of these come under category of intentional tort. The reason they use the word intentional is to indicate that it was done knowingly. All right. So, of course, defamation also falls into this category, right? And you can see that in certain situations, the law will come to the rescue of the victim and, to determine whether they have suffered emotional distress to the extent that they are eligible to obtain some form of damages. Okay, so that's very important for you to understand that one area of torts consists of intentional torts, and these are civil wrongs which was done deliberately by one person to another, and it can result in severe emotional distress. And in the case of defamation, sometimes it will harm the reputation of someone, and that can have some negative consequences. All right, so that's intentional torts. So we looked at it in the last class, and then we sort of looked at areas such as privacy or privacy, whichever way you want to pronounce it. And in certain countries, especially in the West, the individual's privacy is given a lot of importance. All right. Now, so we have looked at the slides on what is privacy, and also how online privacy gets affected through the use of social media, right? So again, I have uploaded a video on that, and if for some reason you did not get adequate understanding on it, please play the video again. All right. Now, also we looked at, in the context of privacy, we looked at personal data. All right, personal data which is protected, all right, because it is private to the individual. So therefore, we have a new area of law called data protection. And basically, data protection aims at, giving legal protection to private information about an individual. All right. So that's also another area related to privacy. And you're talking about privacy in terms of your personal information, right? And we looked at this video. I could not play for you this video on data protection and privacy. I will play it for you today, so that you get a little bit of further information on this area.
In the digital economy, data is of strategic importance. With social, economic, and governmental activities increasingly carried out online, the flow of personal data is expanding fast, raising issues related to storage and use. Current technologies, cloud services, the Internet of Things, and big data as well as future technological innovations and increased connectivity through 5G networks, can deliver enormous benefits. But they also make it more urgent to address various concerns over data and privacy. The challenge for data protection regimes is in managing the risks and addressing the concerns without restricting or eliminating the potential benefits. The role of governments and the industry in protecting online data is of paramount importance. It must be done with a great deal of trust and confidence. This requires collaboration across stakeholders and geographies. Cross-border e-commerce presents developing countries with amazing opportunities, but those countries that want to participate in the digital economy must consider the need for legal and regulatory frameworks to protect the personal data they collect. According to the UNCTAD Global Cyber Law Tracker, around 60 developing countries do not have current baseline protection laws in place, and another 35 only have draft legislation. The United Nations Conference on Trade and Development is happy to offer a platform for discussion on a vitally important subject. As industry players and consumers, as well as governments and international organizations, you will have the opportunity to present your perspectives, outline recent developments, current practices, and consider relevant frameworks. We will discuss how various challenges, including compliance, localization, and interoperability, as well as opportunities related to data protection and privacy, affect the potential for cross-border trade, especially in the context of developing countries. So let's start the dialogue. Where do we go from here? What are realistic solutions? What can we do to address concerns of various stakeholders while at the same time avoiding stifling trade and innovation? How can we make sure developing countries take full part in this global discussion and accelerate their adoption and enforcement of legal frameworks? Welcome to UNCTAD and to the expert meeting on data protection and privacy, implications for trade and development.
Okay, so you can see
In the
how
digital economy, data
Okay, so you can see how important data protection is, especially now that a lot of our activities are online. Right now, like if you look at this particular video, they're always exploring new situations, and this COVID-19 is definitely a new situation. For example, I was told that one of my friends who went to Aeon before they enter into the to do the grocery shopping, they were asked to they had to use the scanning from their phone, and one of the things they said is they wanted the right of access to information that you have in your phone, and they want to share it with third parties, and it was almost like they were compelling most people who want to go in to agree to that condition. Now, of course, a lot of people are not aware of what data protection is, and it is not fair for these kind of businesses to actually compel you to share your personal information with their business partners. Of course, our Data Protection Act in Malaysia does actually protect individuals from such kind of invasions of privacy, but most people do not understand it. So, of course, it becomes a challenge because a lot of consumers do not have adequate understanding in this area. All right. So, this is something for us to think about, right? Like, for example, when we go into shops, they want to take our information like our address, our telephone number, so that they can track us. So tracking our movements in normal situations is considered to be an invasion of our privacy. But in a situation where it involves public health, it you cannot look at it that way, right? But still, after this is over, can people use that information about you, right? So you have to actually have a good understanding on what data protection is and who can do what with your information. All right, so that's basically data protection. Okay, the next thing that we looked at was defamation, all right? And defamation is about freedom of speech, and on one hand, and also the right not to, put false information about someone, out there, either written information online or, in the normal medium, or or speak something that is untrue about someone to the extent that person's reputation is affected. So we looked at this in the last class, and when you talk about defamation, there are two forms of defamation. One is oral and the other is written. Okay, the oral defamation is called slander, and the written defamation is called libel. Now, in today's, should I say, age where you have got internet, information gets spread faster and wider than before. Previously, like you hear about something, it's published in the newspapers, the circulation of the information, the scope of the circulation of the information is not wide. But today, when you put something online, it gets spread all over the world. So of course, you have to see how serious it can be if you actually put false information about somebody online. All right, so the situation of defamation becomes much more serious in this context. Right now, what I wanted to actually show you, you've seen the lecture. That's actually a very good lecture. I hope that if you are not able to grasp it, then please play that video again. Okay, now what I'm going to do also is I will show you a little bit of this slide that will actually take on the basic information about defamation. Now if you look at defamation, of course it's an intentional tort. All right, and originally it was based on common law, meaning it was based on cases decided by the courts, right? And as I've indicated before, it can be slander, it can be libel, and there can also be now defamation directed at businesses. All right, whether you are saying something that is a negative about somebody's goods or somebody's services. All right, so defamation can also now be directed at businesses, right? However, you've got to show four elements, which you looked at in the video. All right. The first is uh, it's an information of fact made about somebody's reputation or somebody's business. Okay, that's the first element of proof. You have to show it is a fact or a statement that is a fact made about somebody's reputation or somebody's business. All right, it's not an opinion, but it is actually a statement of fact. So people can put their opinions, and that cannot be, a case can't be brought against somebody because they have spoken something with regards to their opinion. But if you put information out there, which is a statement of fact, uh, then of course that may be, eligible for court action if it is not true. Right now, so the second element is, right, is that information has been conveyed to a third party, right? So that means you have conveyed that information to somebody else. And as you've seen in the video before, anyone who repeats that information can also be liable. All right. So sometimes when it comes to email, all right, uh, it's basically, if it is email, it's very difficult because email is accessible to everybody who's in that group, right? So sometimes it's very difficult to prove this part, especially if it's an email where there are a lot of people in there. Second element is that that information has been conveyed to a third party. right? Now, third element is you have to show some degree of fault or negligence, all right? That means that this person conveyed some information without checking whether that information is correct, or there was some form of malice, meaning that person had some was mean, had some mean intention to convey that information without making sure whether it was true or not. So, of course, the third element to some degree means that that is the information conveyed was false, but this person had conveyed that information without making sure or without caring whether it was true or not, and that or that person was negligent or careless, without checking, they just published the information. So sometimes when like in our WhatsApp, we forward information without checking whether something is true or not. Of course, you can be in a dangerous situation because people can bring action against you. All right. Fourth element, as you can always see in tort, right? As a result of that false information, right? That's a statement of fact which you conveyed to third parties without checking to see whether it was true or not. uh, the other person have suffered damages. All right. So these are the four elements that you have to prove in defamation. And of course, when you bring an action against the defendant can use certain defenses to protect himself. He can either prove that that information that he posted was actually the truth, because if it's the truth, then the plaintiff cannot win the case, or that it was absolute privilege. Okay, in certain situations, there would be absolute privilege, meaning that person has a right to actually, say those things. For example, if you're a judge who is actually giving, the judgment in a case, and you are saying certain things about the accused, for example, in a criminal case, the accused cannot later go and what do you call it, bring an action against the judge to say that the judge said certain negative things about him which was not true. Of course, in that case, because he's holding a position that has absolute privilege for whatever statements he makes. Qualified privilege is like when you get references, or when certain at the employment setting, when you ask for reference letters, and people actually write recommendations, and sometimes there anything negative in it, that would have got qualified privilege, right? So these are the things that we actually looked at, right? And in the context of defamation, right? Now going back to the other slides. Now, there's another category of intentional tort against property, and this is called fraudulent misrepresentation. And I think all of you have studied about misrepresentation and fraud in your contract law, where the contract becomes voidable because of misrepresentation, or the contract becomes voidable because of fraud. Now, somewhere between fraud and misrepresentation is a category called uh, fraudulent misrepresentation. All right. Now, so when you actually, convey information uh, whereby that information is not correct, it could even be fraud, could be even a fraudulent misrepresentation, all right, because you want to gain some advantage from it by making these statements, but they're not true statements, then you are said to have committed fraudulent misrepresentation, right? because you are misrepresenting the facts so that you can gain, for example, you can gain a contract, or you can, purchase a property, or, along those lines. All right. So some form of advantage has accrued to you. But when you actually conveyed that information, you knew that it was true, untrue, uh, or you didn't care whether it was true or not. And that is called fraudulent misrepresentation. And if the other person has suffered damages, then that person can sue to obtain remedies under fraudulent misrepresentation. All right. Now, what has that got to do with, say your area of, profession, marketing, for example? All right. Now, what if you, made certain fraudulent misrepresentation in your website, right? And this can happen in the context of, sales transactions, all right, where the seller collects payments for goods offered on the internet, but end up not delivering the goods. So the seller has already been paid by the consumer, but has not delivered the goods. This comes under the category of fraudulent misrepresentation. The other category is related to financial investment transaction, where you've got brokers, all right, who actually try to get you to invest in certain companies that either don't exist, or those companies are not doing well, but they sort of persuade you to invest in those companies. Again, that will come under fraudulent misrepresentation. Third category is victims of internet fraud. All right. Normally, people are actually, lied to or deceived, and then their money is taken, right? And this is all the categories of all these internet fraudulent schemes. That too comes under fraudulent misrepresentation. All right. And then, of course, all right, you have got, those people who, for example, if you sue them, they've got defenses. All right. And one of the defenses is that, the information they gave was, as far as they knew, was true. All right. So it's very important that you understand these categories, right? And even though you may not remember, but know that, when you are a victim of internet fraud, you know that if you bring an action, it'll be under fraudulent misrepresentation. All right. Or if you are a business owner and you are, collecting money from your, customers, but you don't deliver the goods, again, the customers can sue you under fraudulent misrepresentation. All right. So again, it's very important for you to understand, all right, what the issue is behind these kind of cases. Okay. Now, the other category is called conversion, right? Conversion. Now, this is a form of theft, right? Actually, when you talk about conversion, it means that you're converting somebody else's property into your own. All right. And in criminal law, it's called theft. In civil law, it's called conversion, right? So normally, if somebody steals your property, they can be charged under criminal law, but you don't charge them, right? You just go report the crime, and then the prosecution will charge that person in the criminal court, right? And then they'll be punished, sent to prison, etc., right, for theft. But you, the victim, has also a right to bring a case against that person, but through a civil action under torts. And that civil action will be the civil action for conversion. All right. So conversion in civil law or tort law is called the taking or using of someone else's property without permission. All right. And when that happens, you can bring an action against that person, especially if you have suffered a loss because that person has taken your property and deprived you of your property. All right. So that's what you call wrongful taking and intermeddling, and it is called conversion. All right. Okay, now, so what happens when there is, like trespass? Again, this is, also, what do you call it? An area where somebody walks into your property without your consent, right? And so that also comes under the category of wrongful takings and intermeddling. So that means somebody's walking into your property, they're meddling into your property, or they're coming and they're a busybody, yeah? They're coming into your property, looking what's happening there. Maybe they want to take something from your property. That's called trespass. All right. So trespass occurs when somebody goes into another's property or they interfere with the right of that person's property without their consent, and this can involve personal property or real property. So if you go into somebody's land and you do something there without their permission, it can be trespass. Or if you take away somebody's car, take away somebody's furniture without their permission, and you're using it without their permission, you can also be charged for trespass. All right. Now, what's the defense normally for trespass? If somebody brings you a case against you for trespass, then you can say one of the defenses you have is actually that property does not belong to that person. Okay, that's a defense that you can use to defend yourself against the plaintiff's case. All right. Now, of course, similarly, trespass can also happen in cyberspace, right? But cyberspace is not the real world, right? It's out there. It's not a real world, but definitely trespass can occur in cyberspace, all right? Now, how does it happen? Trespass in cyberspace, right? Now, you can see perfect examples of cases such as eBay, all right? Now, eBay basically is an auction site, all right? And sometimes you've got different types of auction sites, and sometimes you have what you call aggregators who will combine all these different websites on their website so that their customers have access to all these different auction websites without going to separate websites one by one. So these websites that what do you call it, that gather all the different auction websites under one website so that their customers can be accessing all these different websites from their website. They're called aggregators. All right. And the famous case is called eBay Incorporated versus Bidders Edge Incorporated. Now, in this case, this Bidders Edge Incorporated is a aggregator, all right, and they had allowed all the consumers to come to their website, and the way they set it up, they're using this software robot, all right. However, what happens is because of this particular software, it causes the other websites, the individual websites to crash, all right. So the issue here was there a trespass? All right, there's a trespass only if they had done that without the permission of eBay. All right, so eBay is suing Bidders Edge because they're saying that these people had, used their auction website in their website without authorization, and as a result, their website had crashed. All right. So, issue, was there a trespass, okay, committed or not? All right. So that's an example of trespass that occurs in cyberspace. Right. People coming into your website or people linking your website in their website. That could be a trespass if you did not give permission. All right. Okay, so that is in terms of trespass. Now, another interesting area is trade secrets. All right. Now, For example, if your employees, all right, have access to your information, and they take that information and they sell that information to others, right? That is conversion, right? They're stealing your trade secret and then selling it to somebody else, all right? That also could come under the category of conversion or misappropriation, all right? Like we also saw the case of that Wheel of Fortune, Vanna White, where Samsung used a sort of like a robot that looked like her, right? That's also misappropriation, all right? Example. Or you use a product, or you advertise a product using this image of a famous person. Again, that could be misappropriation, as you can see in the case of National Basketball Association versus Motorola Incorporated. All right. So these are examples of intentional torts, right? And the next topic that I wanted to look at is negligence. All right. So the second category of tort is negligence. Now, negligence basically means that it was not done intentionally, but you were careless to a high degree, to the point that it had caused harm on the other person or the other person's business. All right. And that other person has suffered loss or damages because of that. So in negligence cases, you have to prove once again that the defendant owes a duty of care to the plaintiff. The defendant breached that duty of care, and then plaintiff, as a direct result of that breach, had suffered damage, and defendant's negligence was directly the cause of plaintiff suffering the loss or damage. So these are the four elements that the plaintiff has to prove before he's eligible to get damages in that case. Okay. Now, I will play this video for you so that you have an idea on what is negligence.
In this video, we will introduce negligence. We'll say Perry is crossing the street, and just then, Dudley comes riding by on his bicycle into the intersection too fast, and there's an accident, and Perry gets hurt. In everyday conversation, we would say that Dudley was careless, and that his carelessness caused the accident. But if the parties go to court, we would say that this is a case about negligence. The defendant is being sued for being negligent. Negligence is another name for an unintentional tort. In law school, you'll frequently hear people say that a plaintiff must prove duty, breach, causation, and damages to win a negligence claim. That's a short way of saying that the elements of negligence are: the defendant owed a duty of reasonable care to the plaintiff, the defendant breached that duty of reasonable care, and as a result of the breach, the defendant caused damages to the plaintiff. So using our bicycle accident as an example, let's look at the elements of negligence: duty, breach, causation, and damages. And we'll start with duty. By duty, we mean that the defendant had an obligation of reasonable care to avoid causing this type of injury. To determine whether that obligation exists, courts will often ask whether the accident and the injury were foreseeable. In this case, everyone would probably agree riding a bicycle too fast through a crosswalk can foreseeably cause an injury to a pedestrian who is crossing the street. For this reason, the element of duty is probably satisfied. Dudley had a duty of reasonable care to avoid this type of injury to Perry. Next, let's look at breach. To determine whether Dudley breached his duty of reasonable care, a court will probably compare Dudley to the reasonable person. If the defendant's level of care went below the level of care that we would expect from a reasonable person, we would say the defendant breached his duty of care. So using this chart as an example, we would say that whenever the red line goes below the blue line, the defendant breached his duty of care because he showed less care than the reasonable person would. Turning back to our case, people would probably say that a reasonable person would not speed through the crosswalk, and instead, a cyclist would slow down or stop. For this reason, Dudley was not as careful as he should have been. He was not as careful as the reasonable person, and therefore, he probably breached his duty of reasonable care. Next, we'll look at causation. At this point in its analysis, a court will ask whether the defendant's breach of his duty of care caused the plaintiff's injury. In fact, courts discuss two types of causation: actual cause and proximate cause. We're not going to discuss those in too much detail, but actual cause means if the defendant had done something differently, would the accident still have occurred? For proximate cause, we ask whether the defendant's actions were close enough in time and space to the injury. Based on the facts as we understand them, it seems the defendant did cause the accident, because if he had stopped or ridden more slowly, there would not have been an accident. So it looks like the third element of causation is also satisfied. Now let's look at damages briefly. It seems that there's no dispute that the plaintiff was injured as a result of Dudley's actions. Therefore, we can say that all four elements of negligence have been satisfied. We can predict that Perry will win in his lawsuit because he should be able to prove all four elements of negligence.
So you've seen the video that explained each step of elements required in the negligence cases. Now, I just thought that the video was kind of funny because they showed about the crossing and how it is, expected duty for people to stop at the crossing, which we see in Malaysia and even on our UTM campus, nobody will stop at the crossing because the zebra crossing, nobody would stop, all right? So, normally they will speed through regardless of people waiting to cross, right? So that's an interesting example, which could also show there are certain cultural differences, but nevertheless, what's the purpose of that crossing? The zebra crossing is to say that pedestrians will be crossing and we are supposed to stop, all right? And you didn't stop and injury was caused, of course, then you will be liable, all right? So you can understand the causation must be established. That means you must show or prove that it is because of your negligence that this injury had occurred, all right? So they use the test but for you not stopping the car, this person would not have been injured, all right? That means it does, you are directly causing that injury, right? Okay, that's what they call it, direct causation, right? And nothing happened in between. You hit that person and therefore that person got injured, all right? It's not like you were driving the car, the tree fell, and then you couldn't see, and then you hit the person. So the tree falling also was one of the factors, right? Not the direct factor, right? So that's an example of something happening in between, right? That had resulted in the, a damage. Another issue is about foreseeability. Could you foresee that if you didn't stop the car, that person is going to be injured? The answer is yes. A reasonable person would have stopped the car. But you could foresee if you didn't stop the car that it is going to, that person is going to get injured. So that's the issue about, or the factor about foreseeability. Was it foreseeable your actions will cause harm to another person? If the answer is yes, then you have proved that element, all right, of causation, right? Now, so the issue of but for, right? But for your action, this thing would not have happened, right? I will play that video for you.
In this video, we will discuss the differences between but for and substantial factor causation. And these are really just two types of tests that many courts use to determine whether a defendant caused damage or injury. So let's say we have a defendant here, and he takes an axe to a tree which is right next to a car. The defendant foolishly chops down the tree, damaging the plaintiff's car. Well, in our lawsuit, the plaintiff is going to have to prove that the defendant caused the damage to his car. And this is also a good example of but-for causation, meaning if the defendant had not taken the axe to the tree, let's say he just decided to make a phone call instead, the car would be just fine. The tree would not have fallen on the car. A jury is likely to conclude that but for the defendant's actions, the car would not have been damaged. For that same reason, a jury should conclude that the defendant was responsible for causing the damage to plaintiff's car. On the other hand, let's say we have a plaintiff who has a bad back, and he wants to sue his employer, who he says forced him to carry these big boxes. But the plaintiff also played football, and he enjoyed lifting weights. So was the bad back caused by lifting boxes, playing football, or lifting weights? Maybe all of these factors had a role in causing the injury. So of course our employer will say, look, even if he hadn't lifted the boxes, he still would have ended up with a bad back. So we can't say that but for the boxes, he wouldn't have been injured. Therefore, the employer didn't cause the injury. The plaintiff might not be able to prove but for causation. However, he might be able to prove that lifting the boxes was a substantial factor in causing his injury. The defendant can bring evidence that lifting the boxes was at the least a substantial reason why he was injured. The court will require proof as to how lifting the boxes was a substantial factor. Looking at another example, let's say lightning causes a forest fire, and our defendant for some reason decides to throw a can of gasoline into the fire, and eventually the forest fire destroys plaintiff's house. Well, the gasoline must have contributed at least a bit to the forest fire, but even if he hadn't thrown the gasoline, the forest fire would probably have destroyed the house. In this situation, we might not have but for or substantial factor causation. The house would have burned down even if defendant didn't throw the gasoline, so we don't have but for causation. And the gasoline really didn't contribute to the forest fire, so we can't say the defendant's action was a substantial factor in causing the damage to the house. If you'd like to discuss causation or any other matter related to...
So you can see what is approximate cause. That means it is something that directly caused the injury. Nothing was happening in between, all right? The perfect example was the dominoes. So if you push the first domino and all the others fell, the last domino would be the resultant injury, all right? But if you push the middle domino, right, then the first domino is no more the direct cause of the injury. So that is proximate cause. Proximate meaning anything that is the closest, all right, cause, all right? So if the actions of defendant is the proximate cause of plaintiff's loss or injury, then of course the court will ask defendant to pay damages to the plaintiff, all right? Now we look at another case, which is Roe versus Minister of Health. And basically in this case, all right, you see what is the meaning of foreseeable. So you saw the example of the person crossing the road and this person knocking that person down. Was it foreseeable if we didn't stop the bicycle that this person will be injured? If the answer is yes, then of course defendant is liable to the plaintiff. So similarly, in this case, which I will not be playing, you can play it on your own, Roe versus Minister of Health, that's exactly what happened. All right, two patients were paralyzed because they were injected with this spinal anesthetic. All right, and this particular anesthetic was kept in this small glass ampule, right? This like test tube kind of thing, and they kept it in this this ampule, that's this glass like thing, test tube like thing. But what happened was that test tube had every tiny cracks. All right, and therefore the anesthetic solution in there was contaminated because that tube was cracked, right? And then when the patients were injected, the spinal cord was injected so that they can't feel anything during the surgery, right? That's why they use this particular, Nupercane, right? When they use those cracked, ampules, they use that to inject as an anesthetic. The patients became paralyzed because it was contaminated, right? So of course, they were sued, right? The patients sued the hospital. In this case, they sued not only the hospital, they sued the ministry, the Minister of Health. Now, so the question was this foreseeable? All right, was this, the paralysis of the patients that happened? That was the injury that happened, right? They became paralyzed. Now, was this foreseeable on the part of the hospital and the doctors and the anesthetic medical officers that performed the procedure? Was it foreseeable? All right, was it something to be expected? Right, the court said no, right, because there was no way they knew that those glass ampules were cracked or will crack. All right, it was something unexpected. All right, and because of that, the court said there was no liability on the part of the hospital and the minister, right, because it was unforeseeable, right? So you can understand the context of foreseeability, right? If the court said it was foreseeable, all right, because here they stored it in a particular place, they didn't realize that those glass ampules had tiny cracks, right? They stored it properly, but nevertheless, the crack happened, right? So it was not foreseeable. But let's just say they left the ampule lying around somewhere where it was foreseeable that this will happen, then of course the court would have found them, liable for the injury of these two patients. Okay, so the patients could not win damages in this case, right? So these are examples of foreseeability in the tort of negligence. Okay. Okay. Similarly, okay, we look at another category which is on trespass. We saw that just now. But generally, if somebody trespasses onto your property, right, and that person who trespassed actually came to your property without your permission, but during the time they were in your property or using your property without your permission and they suffered injury, are you responsible for the injury? General rule is the property owner owes the trespasser no duty of care, and he has not any duty to warn people who enter his property without permission about the dangers in that property. All right. So remember, right? If somebody comes onto your property without your permission, or somebody uses your property without your permission, and they suffer harm or injury, you do not owe a duty of care towards that person because they are trespassers. Okay, so that is in terms of duty of landowners or those who are owners of property. They don't have a duty of care towards trespassers. Okay, now, however, right, there's exceptions to the general rule. All right, meaning in certain circumstances, the landowner may owe a duty of care, especially when it comes to children. All right. So if your property has got something that's very bright and attractive, which will attract children, and children sometimes come, they don't know about property boundaries and so on. And if the children get injured in that context, then of course the property owner may be liable in those circumstances. But general rule, you do not have a duty of care to those who trespass your property, right? All right. What about duties to licensees? Who is a licensee? These are people you invite to your property, like your guests. All right. Now, what if you invite people to come to your house and that person gets injured? All right. So, will you be liable because you invited these people to your property? So, when you invite people to your property and they get injured, right? They are on your property with permission, right? So if that happens, then of course you owe a duty of care to these people, right? So because they are licensees, that means they're coming there with permission. Similarly to business invitees. So for example, if you are having a shop, a business premise, and people come into your shop and then they are injured, of course, you will be liable. The business owner or the proprietor of the business will be liable, right? So again, as a business owner, you have to be very, very careful in these circumstances. Okay. Now, the last category is professional negligence. Professional negligence is people depend on your professional advice. They rely on that professional advice. So therefore, you have a duty of care towards that person, right? And if as a result of them relying on your professional advice or your professional service, and that person suffers injury or loss, of course, you have breached the duty of care and therefore you will be liable in damages. All right. Now, I will stop the topic here, right? And then I just want to quickly inform all of you by now, you should be starting to collect information for your topic, group topic that you are doing. Hopefully you are making good progress. See, because otherwise we don't have much time left. So I hope that you're making good progress with your group topic. The next thing is about your tests. All right. Next week, I will post your test that will cover internet contracts. All right. And digital signature. All right. So I'll give you a short test on that, but I allow you to take home and do that test. All right. So, and then I will also post your grades this week for the quiz that you had done. All right. And the assignment that you had done. Now I will post the grades to you. But next week, I will give you your test that covers internet contracts as well as digital signatures. All right. I haven't decided exactly, but it'll be just one or two questions. Now, the topic on privacy, right? You've got on your final exam is actually now broken up into two tests, right? And one of it will deal with privacy. Now, I've uploaded a chapter in your intellectual property week, the week that has got the intellectual property. There's a chapter on intellectual property, and the last chapter of that is also privacy. So you can open up that, and I will actually use the questions from there for your tests, okay? Which will be given later. Now, all of these I will allow you to take home to do your tests, right? So that you can do well, right? So I will give you more information on this in the next class, but next week you will have your test, all right? Thank you. Stay safe.